G'day, watch this.
Professor Robert P. George, the McCormick Professor of Jurisprudence at Princeton University, visited Sydney recently as the keynote speaker at the John Paul II Leaders Forum. Praised by US Supreme Court Justice and former Harvard Law School Dean Elena Kagan as one of the nation's most respected legal theorists, he is celebrated author of 14 books and numerous articles. Mindful of the ongoing judicial activism, I asked the professor whether Australia should be cautious in adopting a Bill of Rights. This was his answer.
Well, the problem is not in a Bill of Rights itself. We Americans are very proud of our Bill of Rights and we highly value it. The danger with entrenching any kind of Bill of Rights was articulated by our own founders, men like Madison and Hamilton, the so-called Federalists who gave us our Constitution. They were concerned that adding a Bill of Rights, and they opposed a Bill of Rights. That's why the Bill of Rights that we ended up getting as a matter of political necessity is a set of amendments and not part of the original Constitution. But their concern was that by listing some rights, we would be implying that these were the only rights or that they were superior to other rights. And of course you can't have a comprehensive list of rights. There are too many. There was also a concern about manipulation, and that, I think, is what nations that are considering the Bill of Rights question need to be concerned about. That is the manipulation by an ideologically driven judiciary if you make your Bill of Rights enforceable by way of judicial review. It's fine if you have honorable justices and judges who will discipline themselves to stick closely to the text or the logical implications of the provisions of the text or the structure of the text or its original understanding. But where you have willful judges who have no qualms about usurping the authority of the democratically constituted people, substituting their own judgments on disputed policy questions for those of the people acting through their elected representatives, then the Bill of Rights can be used as a pretext by such judges, ideologically motivated judges, to work their will and to create what Jefferson warned about, and that was an oligarchy of judges. Jefferson was one of the people who, though supporting the Constitution, was opposed to the very idea of judicial review because he feared that ideological judges would usurp the authority of the people and set themselves up as an oligarchy, thus destroying democracy. Lincoln, Abraham Lincoln, our greatest president who saved our nation at the cost of a terrible bloody civil war, 750,000 men on the two sides lost. But Lincoln, in his first inaugural address, also warned against judicial supremacy, that is, the use of judicial review by ideologically motivated judges to govern the country without any recourse of the people at the ballot box, as our judges are not elected and are electorally unaccountable. When you consider that the draftsman of our Declaration of Independence, Jefferson, and the great emancipator who fought the Civil War and preserved the Union and freed the slaves, Lincoln, had these concerns, then I think you'll see that it's reasonable for any nation that is considering how to protect freedom to think twice about giving too much power to judges in the name of a Bill of Rights to govern the country. So we value our Bill of Rights. It's a very important part of our political culture, but we also have had bad experience with judges who have used the Bill of Rights and related provisions of the Constitution as a pretext for actually violating the Constitution, performing unconstitutional, indeed anti-constitutional acts by which they subvert the principles of democratic deliberation which are at the heart of the Constitution.